Welcome back to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure, section by section, chapter by chapter.
That's the plan. It's all part of this educational series trying to make sense of it all.
Exactly. We want to offer clear, accessible explanations of U.S. patent law and how examination actually works. Super helpful if you're studying for the patent bar, or maybe you're already working in IP.
Right, because the MPP is essentially the rule book for examiners. Understanding their perspective, how they apply these rules, it's just fundamental for anyone in this field. We're aiming to break it down into something practical.
And today we're looking at the very beginning of the examination process. Well, actually, before the real examination starts. We're in Chapter 700, Examination of Applications. But before an examiner gets into novelty or obviousness, there are these initial checks. So that takes us to MPP Section 702, Requisites of the Application.
And right after that, Section 702.01, which covers, obviously, informal cases.
Okay, so 702 first. Requisites of the application, what's the core idea here?
Think of Section 702 as the guidebook for the Office of Patent Application Processing, OPAP. They get the application first.
Right, OPAP.
And they have two main jobs right off the bat. One, does this thing deserve a filing date? And two, is it formally complete?
Filing date, that's the official timestamp, super critical. And completeness, meaning does it have all the required parts?
Pretty much. And a really key point here is how things changed because of the patent law treaty, the PLT.
Ah, yes, the PLT. I remember that being a significant shift. Implemented back in, 2012?
That's right, through the Patent Law Treaty's Implementation Act of 2012. It really altered the landscape for getting that initial filing date for most non-provisional applications.
So how much easier did it get? What's the minimum now?
Okay, so for non-provisional applications filed on or after December 18, 2013, that's the key date, the bar for getting a filing date was lowered quite a bit. Basically, you just need a specification.
Just the spec, the written description. That's it. No claims, no drawings needed right at that moment.
Correct. For most non-provisionals after that date, a specification alone is enough to secure the filing date. It doesn't even matter if it includes claims at that point.
Wow. Okay, but drawings. Sometimes you absolutely need drawings to understand what the invention even is, right?
You're absolutely right.
Oh.
And the law, 35 U.S.C. 113, still says drawings are required if they're essential to understand the invention.
So how does that square with not needing them for the filing date?
It's a timing thing.
Yeah.
Post-PLT, they aren't strictly required at the moment of filing just to get the date for these applications. But you will definitely need them later for examination if they're essential.
So you could technically file just a spec, get your date, even if drawings are clearly needed later. Seems risky.
It can be. The office definitely encourages applicants to submit any essential figures right away. Getting the date might be urgent, maybe for priority, but you'll face delays later if those necessary drawings aren't there when the examiner picks it up.
Makes sense.
Yeah.
And claims. You said they aren't needed for the date either. When do they have to show up?
Claims are absolutely essential for examination to begin. An examiner needs at least one claim to know what the invention is that they're supposed to be examining.
Right.
So if you file a non-provisional without claims, OPAP gives it the filing date based on the spec, but then the office sends out a notice.
Telling you to add claims.
Exactly. A notice to file missing parts, usually. You'll get a set time period to submit at least one claim. If you don't, the application could go abandoned, and you need that claim so the application can be properly docketed to an examiner.
Okay, so spec gets the date for most non-provisionals post-PLT. Claims and essential drawings are needed for examination. Are there any applications where the old way, needing more upfront for the date, still applies?
Yes. The main one mentioned is design applications. For designs, you still need at least one claim and the necessary drawings right at filing to get your filing date.
Got it. Designs are different. So OPAP does this initial check, determines the date based on these rules. What if other things are missing, like, say, the inventor's oath or fees, or maybe some pages seem to be gone?
That's where other notices come into play. Even if it gets a filing date, OPAP checks for other formal requirements. If stuff like the oath, declaration, fees, or even pages of the spec or drawings are missing, they issue formal notices.
Like what?
You might get a notice of incomplete application or a notice of omitted items. These notices basically tell you, hey, you got a date, but you still need to fix these specific things.
Okay. And does the examiner themselves double-check this before they start the substantive review?
Yes, absolutely. It's kind of a final check. Before the examiner really dives into the prior art search and comparing claims, they're supposed to confirm the application is complete. Are all the pages there? Fees paid? Oath or declaration in? It's a quality control step.
So thinking about someone listening, maybe prepping for the patent bar or just trying to get a handle on this, why is it important to grasp this difference between getting the filing date and being formally complete for examination?
Oh, it's crucial for strategy. Knowing the absolute minimum for a filing date can be life-saving if you're hitting a deadline, like a Paris Convention deadline, right? You file the spec, secure the date.
Right.
But knowing what's needed for completeness helps you plan. You anticipate those notices, you get the missing parts in quickly. And honestly, providing a fully complete application, upfront spec, claims, drawings, fees, oath, even if not all needed for the date itself for non-provisional, just makes the whole process smoother and faster, less back and forth with the office.
Sets you up for a better start. Okay, that covers getting in the door and getting formally ready. But now, what if the application gets a filing date, but the content itself is just really unclear, like hard to understand?
Ah, yes. That brings us to MPP section 702.01, obviously informal cases. This is where the substance, or lack thereof, causes problems.
What does the office do then?
Well, it kind of depends on how informal or unclear it is.
Okay.
Scenario 1. It's messy, maybe uses weird terms, but the examiner can, figure out enough to do at least a basic search for prior art.
So they can make some sense of it.
Yeah, enough to get started. In that case, the examiner will proceed with examination. They'll do the search, write the office action, but they'll also point out all the informalities and require you to fix them.
So the process moves forward, but with homework for the applicant.
Exactly. But then there's scenario 2.
Which is?
The application is just unintelligible. So unclear, maybe the language is so convoluted or uses such non-standard terms that the examiner literally cannot figure out what the invention is or what they should even be searching for.
That sounds bad. Does that happen often?
It's rare, the MPEP suggests, but it happens. In that case, the examiner cannot conduct a meaningful search.
So what do? Reject it?
They don't proceed with the substantive examination yet. Instead, they issue a specific form-based notice. It basically says, we can't understand this. You need to revise the application to make it clear before we can examine it.
What kind of things lead to that level of informality?
Usually it boils down to language. The section mentions using really unconventional terminology, words, or phrases that people in that specific technical field just don't use or understand.
Like making up your own names for standard parts.
Kind of, yeah. Or using really unidiomatic English, where the sentence structure or word choices make the description confusing or ambiguous, especially compared to how experts normally communicate in that field.
Is there an example?
Yeah, the MPP gives one. Imagine someone invents, say, a new type of engine, but they describe it using completely made-up terms for all the key components, like calling the piston a reciprocator unit and the crankshaft a rotational power converter.
Okay.
The examiner reading this might think, I think this relates to engines, but I have no idea what these terms actually mean or correspond to in known engine technology. They can't effectively search for prior art related to reciprocator units.
So they're stuck.
Right. In that situation, the examiner might try their best, find some vaguely related prior art if possible, cite it. But they must then require the applicant to revise the application. They'll say, essentially, rewrite this using standard terminology accepted in automotive engineering or whatever the field is.
Makes total sense. You need a common language. Are there specific forms for this?
Yep. The manual points to form paragraphs 7.01 and 7.02. These are the standard ways examiners communicate these kinds of fundamental clarity issues.
Any advice for applicants to avoid getting into this mess?
Well, the best advice is always clarity from the start. But the MPP does suggest filing a preliminary amendment soon after filing if you know there are informalities you need to clean up.
Especially if you rushed the filing.
Exactly. Maybe you filed right on a deadline, like the Paris Convention deadline, just to get the date. Going back quickly with a preliminary amendment to fix clarity, fix terminology, that can save a lot of trouble later.
So the big takeaway from 702.01 is that just meeting the bare minimum for a filing date isn't enough. Clarity is king.
Absolutely. It's not just about following rules. If your application is unclear, the whole examination process gets bogged down. The examiner might misunderstand your invention, cite the wrong art, issue confusing rejections. It just creates delays, costs, and uncertainty. Clear writing is fundamental.
Okay, so let's tie MPEP Section 702 and Section 702.01 together. What's the overarching message?
I think together they really map out that initial journey. Section 702 shows how the PLT made it easier, in many cases, just to get your foot in the door with a filing date. It sets the baseline for formal requirements.
That's step one.
Right. And Section 702.01 is like step 2. Even if you're formally in, is your application clear enough to actually be examined? It highlights that crucial need for understandability.
So minimums get you the date, but clarity and completeness get you examined efficiently.
Precisely. Both sections together emphasize that aiming for clarity, completeness, and using standard practices right from the beginning is really the best way to ensure your application moves smoothly through the whole process. Build that solid foundation.
Don't just scrape by the minimums.
It usually pays off not to.
Got it. Well, this deep dive is, as always, part of our larger series exploring the MAP section by section, and we really need to give a special thank you to Mike Shepard, the creative director who's been organizing this whole audio series.
Yes, thank you, Mike, and thank you for tuning in and exploring these details with us.
Before we go, the necessary disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction.
That's right. For authoritative guidance, please always consult the official MPEP, a qualified instructor, or a registered patent practitioner.
And one final thought to leave you with.
Consider this. We talked about meeting minimums versus aiming higher for clarity. How might going that extra mile in drafting, making your application exceptionally clear and complete from day one, actually influence the examiner's perception and maybe even streamline the substantive examination itself? Does it build subconscious goodwill or just make their job easier, leading to a better outcome?
Definitely something to mull over. Join us next time for another deep dive.